as many of you have not attended educational activities of Life 4 before, I think that might be quite a nice introduction to the topic, or for the others a reminder. Afterwards, Judge Claudia Pina from the Criminal Investigation Court from Lisbon will give us some insights about the validation and issuing process of the European Investigation Order from a practical point of view. We conducted a workshop about the best practices in March in Brussels, and Claudia participated there, and her contribution was highly valuable there, so I think we have the perfect expert for this topic here on my right side. Afterwards, Tanja Fachatala from Fairtiles NGO will talk about accessing e-evidence and challenges to fundamental rights. So it's not really focusing this much on the European Investigation Order, I think, but it's absolutely on point, as it's the e-evidence is what we are going to talk in the next slides when I want to introduce the European Investigation Order. Afterwards, I hope for your contributions and your practitioner views, and so that we maybe can gather some more knowledge about how to apply the European Investigation Order and the further legislation about e-evidence, and also include that in our best practice report, which was already mentioned by Antonio this morning. And as he said, there is a legal part in the end, and we wrote about our best practices gathered so far, but we would be happy to include your thoughts there as well. So for you, I think most of you will know that the European Investigation Order is a directive from 2014, adopted in 2014 to be precise, and came into force 1.5 years ago in May 2017. It replaced nearly all instruments or all legislation on the justice cooperation in Europe, and all member states have adopted the European Investigation Order Directive right now. All member states, Denmark, not all member states, Denmark and Ireland opted out. So for 26 member states at the moment, it's applicable. As this is a legal panel, I'm very sorry to present you the definition what a European Investigation Order is. The European Investigation Order is a judicial decision which has been issued or validated by a judicial authority of a member state, the issuing state, to have one or several specific investigation measures carried out in another member state, the executing state, to obtain evidence in accordance with this directive. So not just reading this out, also a little bit of explanation. First of all, we have the issuing state and the executing state. The one of you who are familiar with mutual assistance will know that this is a change in the wording. So right now it's not mutual legal assistance any longer, it's mutual recognition right now, and that's also what you can see in the wording here right now. And so you can issue one or several specific investigation measures to obtain evidence. As you can see, that's not specific on e-evidence, and that's one criticism of what you can say about the European Investigation Order. We were discussing this yesterday during our dinner. So, by the way, we were not only discussing European Investigation Order stuff there, but so that's definitely one point which you can say about the European Investigation Order. But you can use the European Investigation Order to obtain e-evidence, and this works like the following. You can see the member state A on the left-hand side. And there you have the law enforcement agency having the idea or having the need of getting electronic evidence in another member state or a service provider which is located in another member state. Then they contact the judicial authority. The judicial authority will contact the judicial authority or the law enforcement, depending on the national system, in the member state B, contacting the service provider. Service provider is sending the e-evidence back to the judicial authority, to the judicial authority in member state A, and then to the law enforcement agency in the member state A. So you can see that's a very long procedure. Still, it was even worse before when we had the mutual legal assistance. And you can see in the printed in orange down there, 120 days is the time limit for this process. That's an advancement or an advantage compared to mutual legal assistance, but it's not very fast either. So speaking about the European Investigation Order, when it comes to the really doing it and getting the evidence, you have to use a form. That's one of the advantages as well of the European Investigation Order. You have 3 annexes of there, Annex A, B, and C. Annex A is kind of the heart of the form of the European Investigation Order, and you have to say, what do you want, who are you contacting, so what are the measures you would like the other member state to carry out? What's the reason? What's the criminal offense you have in your legislation? Therefore, and so that's what Annex A is about. Annex B then is that you confirm as a member state B getting the European Investigation Order that you received the European Investigation Order, and by saying that you have received the European Investigation Order, the time limits which I presented very shortly with 120 days starts. So that's very important. Speaking about the time limits, going more into detail, I would like to mention the Article 12, which is very relevant for the time limits in the European Investigation Order. Annex C, when you have special measures like the interception of telecommunication, then you have also to fill in Annex C and send it to the executing state, to the executing authority there. And I think Claudia will also tell us something about the interception of communication or of telephone interception. Okay, and now compared what the future looks like. I was mentioning the European Production Order very shortly in the beginning, and down there you can see the slide from the beginning about the European Investigation Order and obtaining e-evidence by using the EIO. Right now we have a much faster process, but yeah, you have not the judicial authority in the member state B, as you can see, and the service provider is directly sending the e-evidence to the law enforcement agency. I'm not quite sure about this diagram, I have to admit, as you probably know, the e-evidence is changing every week, nearly every week, and the last change was on the 12th of December, but we are very lucky that we have another panel in the afternoon, so maybe they can introduce us more into the deeps of the European Production Order. Okay, having said all this, I would like to introduce you to Claudia Pina. Claudia Pina is a judge since 1999, and she's serving right now at the Criminal Investigation Court of Lisbon. She has completed postgraduate courses in criminal investigation and evidence, and has a master degree in the area of criminal procedures. She is especially focusing on financial crime and corruption, but also on digital evidence and international criminal cooperation. So I'm very glad that Claudia is here, because I think she's the perfect expert for the European Investigation Order when it comes to e-evidence. All right.
So, hi, good morning, everyone. As Louing was so kindly saying and in introducing me, I'm an investigating judge. So I'm not really an academic. I'm a practitioner of law. And we, as practitioners of law, face difficulties and try our best to overcome them. So it's here? Hey. Oh. Oh, okay. Some technical issues. So, here. And to find the best solutions for them. And I hope I can contribute to the discussions and for all of us to share some ideas on how best we can do our jobs as law enforcement or as judicial authorities. With the Lisbon Treaty and the creation of the area of freedom, security, and justice, judicial cooperation in criminal matters was highlighted, and it should obey the principle of mutual recognition of judgments and judicial decisions, but also it should include an effort of the European institutions to approximate laws and regulations in all member states so we can all function in a similar way for common goals. Within this area of freedom, security, and justice, the European Parliament and the Council should adopt measures to facilitate cooperation between judicial or equivalent authorities in member states in relation to proceedings in criminal matters and enforcement of decisions. It was in this light that the European Investigation Order and the future European Production and European Preservation Order were created. As Lewin was saying, in 2014, the directive for the European Investigation Order was issued. The European Investigation Order is an instrument of international cooperation in criminal matters, and it's in fact a judicial decision issued or validated by a judicial authority of a member state, and it aims to gather evidence in a different member state. The European Investigation Order and the other instruments of judicial cooperation in criminal matters should be seen as a dynamic system. Everything should fit together in place and work in a flow where we have the European Investigation Order in one part, but everything should be under the European Charter of Fundamental Rights, and such as the fundamental rights to the presumption of innocence, the fundamental rights to fair trial, as Tanja will certainly address more in depth. And they, at this point, should also have the boundaries of GDPR. So under and above the European Investigation Order and the Preservation or Production Order, we should remember the fundamental rights of the European citizens related in the stated in the Charter, and also the privacy rights stated in GDPR. The European Investigation Order was created due to the ineffectiveness and limited use of the European evidence warrant and the continual use of mutual legal assistance instruments. This, of course, were slow, they were full of obstacles, and so there was a need for a swifter and more effective instrument, and thus the Parliament and the Council approved the directive to strengthen judicial cooperation accordingly to Article 82 of the treaty. So when you see the European Investigation Order, you should remember that the main goals are speed and flexibility, without jeopardizing fundamental rights, of course, and that this is an instrument that overcame the classical mutual legal assistance. This is an instrument of mutual trust and mutual recognition, so the grounds for refusal should be reduced to a minimum. In a very short overview, the European Investigation Order was created by Directive 2014-41. Ireland and Denmark are out. In fact, Denmark, as you may know, is not a part of the European area of freedom, security, and justice. So it's completely out. And in the case of this directive, Ireland has chosen to opt out. All other remaining 26 states have transposed the directive so far to national law, And you can check this in the status of implementation in my last slide, and I hope it will be available for you. There is a link, and you can click the link and access all relevant national laws. In your practical work, you can have a direct pinpoint to what you are looking for. The directive does not apply to joint investigation teams. Of course it doesn't, because it would be pointless. A joint investigation team does not need this kind of instrument. It will work directly within its members. And the preamble of the directive also states that it does not apply to cross-border surveillance. Although in this point, and I will explain further on, this is not very clear, or at least maybe not very correct, but we'll discuss it a bit further. The European investigation order must be issued by a judicial authority or validated by a judicial authority, and it will be issued to obtain evidence in the possession of the executing state or to be gathered by the authorities of the executing state. The directive does not have a specific procedure for the gathering of digital evidence by seizure, which means information stored in the cloud is not directly addressed, and that is one of the reasons there was a need either to amend the directive or to create a new instrument, and the Parliament and the Council opted for this second option and created the regulation for the European Production and Preservation Order. The issuing and validation of the European Investigation Order has the form that Lewin has showed you, but even though it gives you kind of a roadmap, please do not consider it to be a smooth path of cotton candy, because it's not. If you ever been faced with a form like this, it's difficult to fulfill. It may not be immediately clear to you exactly how you should fill it. So please be very attentive, very careful. Consult the IGN page website and Fish Belge, but also don't trust it completely. Unfortunately, they have not been updated as they should. And before coming here for this conference, I checked the Portuguese measures and how we could use the website and Fish Belge, and I got to the conclusion that were incorrect for Portugal. So it may be incorrect for other countries. So be careful. Use it, but be careful. Use one form, even if you need more than one measure. And then you come to this question: who should issue the investigation order? Maybe it's very clear in your national law, and that is the case for Portugal, that it should be a prosecutor. However, there are several investigative measures that cannot be ordered by a prosecutor. They must be ordered by a judge. So you could have a situation, and I'm sure this happens in other jurisdictions, in which you need two competent authorities for the European Investigation Order. You need a prosecutor and you'll need an investigating judge. So you can have two solutions. One is for the prosecutor to issue the European order and ask for the judge's validation. Could be a way to solve this problem. Or you could contact the executing state and have the European investigation order issued by a prosecutor and executed in the executing state with an order from the judge. I think we still do not know exactly what is the best way because the transposition is quite recent, and I think we should probably see how this will settle in the future. But I just want to stress out that this is a point that can raise some doubts and difficulties. The EAO should be issued using Annex A, and you should remember that being this very complex to fill in, you may need an informal channel. So if you have it, use it. If you can contact your colleague in the executing state, you should try to contact him or her to make sure you are both synced for the best solution. And also, if you have doubts, please use Eurojust. Eurojust is there for all of us to use. Don't be afraid to use it. You should know and contact your national desk if you have the need for it. So please don't be shy and use the channels you have. And please do remember that if you are issuing more than one investigation order for different states, then of course you should contact Eurojust because it will be of great help in order to obtain the best possible execution. And when you issue, do remember that we are all very different. We have different culture, different background, different legislations, and you really don't know that if something might be very clear to you, but it might mean something completely different for another person in another jurisdiction. Imagine you are a traveler from faraway land, a Portuguese explorer traveling the world, and you arrive to an island where the natives are very friendly and very cooperative, and they want to help you. And you are very hungry, you've been away at sea for months, and you tell, please give me some food. I need food very, very, very much. And the natives say, of course, we will. And you wait hours and hours and hours on end. And in the end, they bring you a very nice plate of fried cockroaches because they are giving you their best. It's their best food. And for them, waiting hours for food, it's totally normal because they only eat once a day. So if you can think of this example for judicial cooperation, it's more or less the same because what is food to you is one thing and for the other is another. And urgency definitely means something different in every culture. So when you issue, be clear. Be very clear, be very detailed, precise what you need and why you need it, because the directive demands the obedience to proportionality and necessity, and detail why it is urgent and what it is urgent to you. Because urgent may mean less than 48 hours to me, and it may mean a week to you. So we need to know exactly where we stand. You should use the forms that you can download from the EGN website. Be very precise also in detailing the facts of the crime, because again, what is safe in your jurisdiction may not exactly be the same in another jurisdiction. And another very interesting and very important point in detailing is formalities. you may need a special formality to be fulfilled in your jurisdiction, and that is completely clear to you exactly what that formality is, but it may not be to the other person. And I had this problem when I asked the search and seizure of documents in a house search, and I issued the request for the documents. I got the documents, but I didn't get how they were obtained, exactly where they were located in the suspect's house, exactly what time the police entered his house, and I need these details for my case. And I had to ask to the state where the request was issued to give me those details, and they were amazed. Why do you need this? We'd never do this. We just sent you the documents. But I need this in my case files. So remember all these details when you fill in the form because they are important to you and they might not be clear to your counterpart. The interception of digital evidence and telecommunications is not clearly stated in the directive. All interceptions fall under Article 30 and 31. And the seizure of data and information stored in the cloud is not directly addressed. And it will, or it may, raise issues of extraterritoriality. These issues will be solved with the production and preservation order regulation. But until then, we need to use the IAO directive to obtain evidence in this way. We can also have problems because I can access evidence in the cloud if the suspect gives me permission, even if the cloud, of course, you know it doesn't really exist, is located in another jurisdiction, or I can have a forensic tool from my cyber team to, let's say, hack the computer and get the evidence. And you may gather valid evidence in this way, depending on your national law. I have the conviction that in Portugal we can obtain valid evidence in this law, but please bear in mind that until the production order is into force, the issue may raise several doubts. Interceptions should be executed in the same way under the same modalities as if they have been ordered by an authority of the executing state, complying with the formalities and procedures expressly indicated by you as the issuing authority. And another problem that often arises with interceptions, either they are digital or they are simple telephone interceptions, is the issue of privilege. The most common privilege you may have is the client-lawyer privilege. So you must, as executing authority and as issuing authority, remember this problem. Real-time interception even have more dangers regarding the problem of privilege, but also in every interception there's the problem that you may intercept information that falls under the core of privacy protected by law of the executing state. It usually means sexuality, sexual orientation, religious practice, and you should consider which state can control privilege, either in real time or in all kinds of interceptions. For me, they should be both states. It's the best solution, but when you are in need of real-time interception, this is more of an issue, and you may need real-time interceptions under Article 28, number 1b, for instance, if you need to follow a drug delivery and you need the police to control the delivery with real-time interceptions. This is quite a common situation for the need of real-time interceptions. In this way, what I would suggest as the best practice, it would be for the executing state authority to authorize the real-time interceptions, so give it to the police for the following of the drugs, but make a reservation on the use of that evidence in court in a later procedure and record all information to control privilege and sensitive information. It may be complicated, but we cannot close the door to real time. It's stated in the directive, and it's a very important police work tool. But we also must remember the European Charter of Human Rights and all the fundamental rights that we as judicial authorities must protect. So there's this very, very delicate balance that we always face between investigation and fundamental rights. And I propose this solution, but of course, if you have better thoughts and ideas, I would be very happy to hear them. For now, real-time interceptions also pose a problem in practice. How do you do it? We don't have yet, unfortunately, a tool to gather them directly from one authority to the other. Let's say the Spanish police needs to intercept in real time a drug dealer in Portuguese territory, and they cannot do it directly in a platform without passing to the Portuguese authorities. So until we have it, the fastest, swiftest way, if you really need real time, have a JIT, or you can use the presence of police officers from the issuing state in the executing state, which is not very cost efficient and it's more complicated. But I hope in the future we'll have that platform, and I know it's being built and there's an effort for this. Last but not least, I want to tell you about cross-border surveillance. And again, we come to the same problem as I was referring. It's the use of words and how they are misleading. Cross-border surveillance is quite a misleading word because it may mean two different things for two different people. And I've had this problem with a Czech colleague, and he told me, you cannot have cross-border surveillance in the directive because it clearly states we cannot have it. And in the Czech Republic, we have this problem because the law that transposed the directive allows it. And I said, no, you're crazy. Of course the directive allows cross-border surveillance. So which one of us is wrong? None of us is wrong. We are both right. Because cross-border surveillance may mean police cooperation or may mean judicial cooperation. And police cooperation is, of course, excluded from the directive. The directive is an instrument of judicial cooperation. Police cooperation is excluded because it is addressed in the Schengen Agreement, Article 40. So the directive is not built for police cooperation, and cross-border surveillance as a form of police cooperation is totally out of the directive. But as a form of judicial cooperation, it can exist, and it should be requested with the directive. Coming in again to the easiest example of drug trafficking. The Spanish authorities may need the surveillance of a drug dealer that is meeting his Portuguese counterpart, which happens very often. They are quite good friends, and they cooperate effectively. A common form of cooperation would be Spain, Portugal, Morocco. And they have these business relationships together, and we need to follow them. So the Spanish authorities may need to gather evidence about a business meeting between a Portuguese, a Spanish, and a Moroccan drug dealers. How should they do it? If they need to document, let's say, that meeting to use in their case file, with photographs, with following the suspects, they should request within the European investigation order. In the Portuguese law, the gathering of photographs of a suspect should be made as a judicial measure. It must be authorized by an investigating judge. So the correct way would be to send an European investigation order to Portugal for the Portuguese police, with or without the help of the Spanish police, to follow this suspect and to photograph that meeting to gather that evidence. So remember, words are so misleading, and that's the best thing to do is communicate, talk, and be very open to the idea that everyone thinks differently, and that we must talk as much as possible and change ideas as much as possible. In the last two slides, you can find the links for the legal instruments and institutions that you can search for if you need or if you are interested. So thank you very much for your time and attention. And thank you very much to Professor Medina for inviting me to this conference. And if you have any questions, you can address them now, or I'll be here later on to start.
It requires judge approval, but if this one is issued by only prosecutor and sent to executing state, and if it is completed in this executing state, the lack of judge approval is completed in the executing state. According to your jurisdiction in Portuguese, is it valid? Is it legal?
I think the best solution would be for the prosecutor in the Portuguese case file. Imagine the public prosecutor wants to conduct a search in Spain, a house search, and that would need the approval of a judge. It should ask in his own file, the Portuguese file, to the judge, if the judge authorizes the request. Probably the judge will. The prosecutor issues the European investigation order, because by Portuguese law, only a prosecutor can issue an European investigation order, and then he can request for the Portuguese investigating judge to validate the European investigation order. I think it could be the best solution, but I know that in practice it has been done in Portugal in a case where the prosecutor managed to informally contact his French counterpart to issue directly, and in France, the French investigating judge authorized the house search. But I don't think it's the best solution. For the correct validity and control later on in the case file of the situation, I think it should have been asked the validation of the Portuguese investigating judge.
Thank you. I have another question that can be answered by anyone in the room. Are you aware of any reason for these two states to opt out of this directive?
Well, they
Denmark
are
and
complicated.
and are they expected to join soon?
No, Denmark is totally out. So Denmark only has as instruments the European arrest warrant because it was prior to the Lisbon Treaty, and so Denmark is out of this instrument. Ireland and the United Kingdom have a reservation in the Lisbon Treaty, so they can opt in or out of the instruments. In this case, the United Kingdom has chosen to opt in to the European Investigation Order, and Ireland decided to opt out. I really don't know why, but it was their right to do so.
Thank you. Any further questions? Yes, please.
Congratulations for the
Thank you.
presentation in the first place. Now, concerning the gathering of evidence and digital evidence, the proposed regulation, the e-directive package, regulation and directive, states, and we will see if this will be the case, but supposedly it will be the case, a new logic for the problem of transterritoriality of the data, okay? So we don't go after where the data is stored, we go after the company that stores the data with our legal representative to abide the so forth orders issued by law enforcement or by judicial authorities. Do you think that this will be an issue in terms of legality and it is a good and practical solution, yes or no? And related to this, you have two forms of evidence that you can gather. One that it's voluntarily presented by the OSPs, another that is judicially effective if you issue an order to them. That part will solve the judicial order, but the voluntary production raises some issues of legality. Do you think that those issues of legality are valid even when we consider that they are presenting evidence that they collect in their own and their own applications, but it's third-party data? Do you think that that causes a legal issue? Yes or no? Thank you.
Well, too much information to address, but I will try my best. Well, the issue of extraterritoriality has been discussed in the last 2 years, I think, and it was, let's say, clicked by the case that opposed the United States government to Microsoft and information that was stored in Ireland. The United States solved their problem with the Cloud Act, and Europe needs to solve the problem also. So we are creating an instrument, and I hope it will be enforced in 2019 for the very clear obligation of service providers to give information to judicial authorities regardless of where that information is stored, because the right to conduct a company is also a fundamental right of companies that is protected in the European Charter of Fundamental Rights. So companies can have their own agenda either because of costs or any other reason that does not concern the state to store data wherever they think it's best for them. So, but that fundamental right to conduct a company cannot obstruct criminal investigation. So again, we come to balance. The regulation aims to address this problem and force the companies to give data for judicial reasons. If they give the data without an order from a judicial authority, either a prosecutor or a judge, depending on the jurisdiction and the kind of data we are talking about, then I don't think it may not be valid, because again, they also have obligations to their clients that should be protected in GDPR. So that will raise issues, for sure. If they give the data voluntarily, I think it will be a problem. Also, maybe we can solve that problem if they give the data and the judicial authorities validate that fulfillment later on, because we wouldn't be requesting something that we already have. It's stupid, and the regulation clearly states necessity also. So we have it, it's no need to ask it again. But before you have that validation from a judicial authority, of course, I think that the problem may arise. Yeah.
I would like your opinion regarding how can you assess in these days that an e-evidence is coming for the right sources, even in international cooperation. And I give you an example. Last week in the Hague Hacks, we were confronted with people that were there. They asked asylum because their own government were producing fake accounts with their information, reporting that they were terrorists, and because they would like to see them extradited and they would like to have them in their system. And well, we were not confronted till now with that kind of malevolence. And who audits, who takes care of this high level of checking this evidence when we have now governments producing fake evidence to bring to the courts, or using the courts as their own mechanism to pursue their nationals? What is your opinion on that?
Well, it really depends what you are talking about, because if we are talking about European Union, we must assume that we all respect the fundamental rights of the Charter, and we all respect the boundaries and the rights that are stated in the treaties. So that problem cannot really arise in the European Union, although we have some states that are stepping away from the rule of law, like Poland or Hungary. And of course, we must be very careful, and there are rulings about Poland at this point in the European Court of Justice. But we must not step away from mutual trust, not yet, not until we clearly assess this. If we are talking about a different state, let's say Russia, or a state that clearly does not respect, any other state who clearly does not respect the rule of law. And I know that there have been states who have abused the Interpol alert system, but they are not European states. And there are boundaries, and there are clear limits to the transmission of evidence with the regulation to certain states. So in that case, that situation you are referring to will be clearly protected in the regulation, and I think that the person that we'll talk about may address it better. So if we are talking about a third state, those limits will be considered, and I don't think the evidence will be transmitted. If we are talking about a state that's been stepping away from European values, but it's still in the European Union, maybe that problem will arise if the service provider clearly says it. And it may be a situation in which the service provider may refuse, and there come to a discussion about it. But I still think we should be based on mutual trust and mutual recognition, because if not, European instruments will simply crumble. I don't know if I answered you. I hope so.
Any further questions to Claudia? Sergey, yes, please.
Thank you for your presentation. My question goes in line with what you mentioned. It seems as if the European investigation, as it is right now, it's not so practical for you judicial authorities. That you mentioned the possibility of reaching out, contacting your counterpart in another member states. How do you think that the foreseen platform envisioned by the Commission might benefit that and make this instrument more useful for you and more easy to issue?
Well, one thing that I truly believe in, and that's why we are all here today, we must put our time, effort, and money in building better platforms. The EGN platform at this point, for me, it has serious problems. If you cannot trust it completely, it's not very useful. And we are in a point where we can starting to have access to legal tech tools, to artificial intelligence. It would be wonderful to have a form that could be linked directly to our case files. Like you have the form and you have help buttons. You have the form integrated in your own system. And I take care of my files in a digital platform, but it's very basic. If it was all interconnected, of course, with all the problems of security this raises, it would be great, and I hope it will happen in the future. At this point, we don't have it, simply, we don't have it. I hope the future will be to go towards, forward in building better legal tech tools, and the e-evidence and the e-codex. I didn't mention e-codex, but it's a wonderful project that's still not implemented. So now we don't really have the tech tools, so we use what we have, humans.
And at the expense of spoiling a little bit the topic that I will discuss this afternoon, do you think that it's wise to, considering what you say, that right now we don't have the tools, but they might come in the future, it's wise to launch a new proposal for regulation on precisely these issues of cross-border accessing of data when we haven't got the time to implement and make an appropriate use of the European investigation order, because of its infancy, but just transposed very recently.
Well, it's been used, and you cannot expect to create something as new and as revulsion. Really, it's a revolution in the way states cooperate in criminal matters. Mutual trust and mutual recognition are the highest level of cooperation. So, of course, it's very new. It's not easy, and we are struggling, but we have to keep going. And as we keep going, and when you create something new, you can never expect it to be perfect. Mm-hmm. Nobody is born perfect. We become better. So that's what I hope it will happen. So I think we should go forward.
Okay, thank you.
Thank you, Sergey. Thank you, Claudia. Yes, as the last words were, we should go forward. Sorry, I have overseen you. Please.
Sorry.
Congratulations for your presentation. I'm Stratos Matakoulias from Hellenic Police. I would like to ask for another procedure about the Convention of Budapest, which is already a national law in Greece, and about the 24/7 network. this is another procedure of cooperation about cybercrime. Are there any differences, or is there any conflict between these two procedures about investigating?
Well, I'm not as familiar with the Budapest Convention, but it's a convention, and the Portuguese jurisdiction opted for a different solution, which was to transpose into national law the most important parts of the convention. But the thing is, the European investigation order is, at this point, the only way you can request evidence to another member state, digital evidence, until you have the production order. So, although I'm not quite familiar to exactly the procedure you are referring to, in Greece, if you want to have a digital evidence gathered in a different state, you must use the European investigation order.
Yes, but in this convention, there are about 70 countries around the world. And we have contact points in every country, and we may have a direct request for cooperation without prosecution, without the prosecutor, without the judicial system. And
well, the two instruments don't exclude themselves. The Budapest Convention and the directive, they do not exclude themselves because they have a totally different scope. The European Investigation Order is for European member states. If you are dealing with outside of the European Union, you need to use MLA requests, or you have to use another cooperation instrument like the one you are referring to. So they are not mutually excluded.
Thank you.
Thank you. I know your view from the German perspective. The German prosecutors told me the same, that they still use it, the system which was implemented under the convention, the Budapest Convention, and they still use the contact points from the 24/7 system. So I know that this is still what is done in practice somehow in some member states, but with the new European legislation, maybe there's a change of how to go on, how to proceed with this one. All right, if there's no further question for the moment, then we will continue with... Okay, one minor question, please.
Just a minor question. Will it be integrated, the EPI as is presented, or the EIO directives, with the EPPO, which is planned to be launched in 2020, the European Prosecutor's
Office,
yes. How will the connection be between those?
That's also two different things. Carlos wants to answer.
That.
Yeah, you can. So
Because actually working with the European Union in a group of countries that are transposing the case management system, creating the case management system of the EPPO. And I can tell you one thing, it's been a year and a half of discussion so far, and we still haven't agreed a final architecture of the system, okay? Because there is one thing that is very important. You have in every single participating member state, because not all European member states are participating member states in the EPPO office, the problem is that each and every single one of them has different rules, okay? So you need to make a functional analysis at every single one of them if you want to have a complete and overwhelming system, which is the proposal of the Commission, which is inexequible up until 2020, which is a target. So some group of countries is trying to opt a different solution, which is for them to have a general management of information case management system, which is more basic, and then utilize the specific national countries' case management systems. This is the other solution. But there is always a problem. Who has the control over the data? And that problem, I can tell you, is not solved yet. Okay?
Thank you.
You're welcome.
Perfect. Thank you a lot. Okay, so right now we will continue with